Hello and welcome everyone. So we are discussing about the salient features of the constitution. এই ভিডিওটোত আমি বাকি থাকা ফিচার্স খিনি ডিসকাস কৰিম. So let's see. So directive principles of state policy or DPSP. They are enumerated in part 4 of the constitution. They can be classified into three broad categories, that is socialistic Gandhian and liberal intellectual. The directive principles are meant for promoting the ideal of social and economic democracy. গতিকে ফান্ডামেন্টাল রাইটসে মেইনলি প্রমোট করে পলিটিক্যাল ডেমোক্রেসি আর ডিপিএসপি এ সোশিয়াল আর ইকোনমিক ডেমোক্রেসি প্রমোট করে. দেন they seek to establish a welfare state in India. Next, the directives are non-justiciable in nature. So আমি জানো যে when the fundamental rights are violated, one can directly go to the Supreme Court or High Court. কিন্তু directive principles যদি violate হয়, we cannot go to the court of law. So they are non-justiciable in nature. Next, fundamental duties. These were added during the operation of internal emergency by the 42nd Constitutional Amendment Act of 1976 on the recommendation of the Swaran-Singh Committee. Then one more fundamental duty was added by the 86th Constitutional Amendment Act of 2002. So the part 4A of the Constitution, which consists of only one article, that is 51A, specified 11 fundamental duties. Then a secular state. আমি জানো যে ইন্ডিয়ার কোনো পার্টিকুলার অফিসিয়াল রিলিজিয়ন নাই. So we follow secularism, that is giving equal respect to all the religions. Our concept of secularism is different from that of the Western concept. Western concept mote secularism hol a complete separation between the religion and the state. So our constitution এনেকুৱা কি provision আছে যাৰ দ্বাৰা আমি গম পাওঁ যে ইণ্ডিয়াখন এখন secular state হয়. এই provision কিটা হল The term secular was added to the preamble of the Indian Constitution by the 42nd Constitutional Amendment Act of 1976. যদিও secular term to 1976 তে ইনক্লুড কৰা হৈছিল, ইয়াৰ আগতেও এনেকুৱা বহুত প্ৰভিজন কনষ্টিটিউচনত আছে যাৰ দ্বাৰা আমি গম পাওঁ যে ইণ্ডিয়াখন এখন সেকুলাৰ ষ্টেট হয়. সেই প্ৰভিজন কেইটা হ'ল The preamble secures to all citizens of India liberty of belief, faith and worship. Then under Article 14, the state shall not deny to any person equality before law or equal protection of laws. Then the state shall not discriminate against any citizen on the ground of religion. Article 15. Then equality of opportunity for all citizens in matters of public employment under Article 16. Then all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religion under Article 25. Then every religious denomination or any of its section shall have the right to manage its religious affairs. Then no person shall be compelled to pay any taxes for the promotion of a particular religion. Then no religious instruction shall be provided in any educational institution maintained by the state. Then any section of the citizens shall have the right to conserve its distinct language, script or culture. Then all minorities shall have the right to establish and administer educational institutions of their choice. Then the state shall endeavor to secure for all the citizens a uniform civil code under Article 44. গতিকে ইয়াৰ আগৰ প্ৰভিজন কিটা যিকিটা আছিল Article 30 লৈকে হেকিটা আছিল ফান্ডামেন্টাল ৰাইটস আৰু Article 44 টো হল ডাইৰেক্টিভ প্ৰিন্সিপাল অফ ষ্টেট পলিচি. ইউনিফৰ্ম সিভিল কোড মানে হল ফৰ এক্সাম্পল এতিয়া আমি জানো যে হিন্দুৰ পাৰ্সোনেল ল কিছুমান আছে আৰু মুছলমানৰ সকলৰ এটা পাৰ্সোনেল ল আছে নিজৰ, কিন্তু ইউনিফৰ্ম সিভিল কোড মতে ভাৰতবৰ্ষৰ সকলো নাগৰিকৰ এটাই ল হ'ব, হেতুকে আমি ইউনিফৰ্ম সিভিল কোড বুলি জানো. Then universal adult franchise. Every citizen who is not less than 18 years of age has a right to vote, irrespective of his caste, race, religion, sex, literacy, wealth, and so on. The voting age was reduced to 18 years from 21 years in 1989 by the 61st Constitutional Amendment Act of 1988. দেন সিঙ্গল সিটিজেনশ্বিপ, আমি জানো যে ইণ্ডিয়াৰ অকল এটাই চিটিজেনশ্বিপ আছে, সেইটো হ'ল ইণ্ডিয়ান চিটিজেনশ্বিপ। কিন্তু আমেৰিকাত কি হয়, তেওঁলোকৰ আমেৰিকান চিটিজেনশ্বিপৰ উপৰিও তেওঁলোকৰ যি যি ষ্টেটৰ পৰা তেওঁলোকে বিলং কৰে, তেওঁলোকৰ ষ্টেটৰ এটা বেলেগকে চিটিজেনশ্বিপ থাকে। চ' দ্য চিটিজেন অফ USA ফ'ল' ডাবল চিটিজেনশ্বিপ। দেন আমি য'তে জন্ম লাভ নকৰোঁ কিয়, যিকোনো যি ৰাজ্যতে আমি নাথাকোঁ কিয়, উই এনজয় দ্য চেম পলিটিকেল এণ্ড চিভিল ৰাইটছ অল অভাৰ দি কাণ্ট্ৰি। দেন ইণ্ডিপেণ্ডেণ্ট বডিজ। চ' আমাৰ কনষ্টিটিউশ্যনৰ প্ৰভিজন মতে আমাৰ কিছুমান ইণ্ডিপেণ্ডেণ্ট বডিজ আছে, যেনে ইলেকশ্যন কমিশ্যন টু এনচিয়ৰ ফ্ৰী এণ্ড ফেয়াৰ ইলেকশ্যন টু দ্য পাৰ্লিয়ামেণ্ট, টু দ্য ষ্টেট লেজিছলেচাৰ, টু দ্য ইলেকশ্যন অফ দি প্ৰেচিডেণ্ট অৰ ভাইচ প্ৰেচিডেণ্ট। দেন কণ্ট্ৰলাৰ এণ্ড অডিট জেনেৰেল অৰ কেগ to audit the accounts of the central and state governments. He acts as the guardian of the public purse and comments on the legality and propriety of the government expenditure. Then we have UPSC or Union Public Service Commission to conduct examinations for recruiting all India services and higher central services and to advise the president on disciplinary matters. Then similarly, we have a State Public Service Commission in every state to conduct examinations for recruiting the civil servant and to advise the governor on disciplinary matters. Then, emergency provisions. So, our Constitution of emergency provisions include to safeguard the sovereignty, unity, integrity, and security of the country, the democratic political system, and the constitution. So we have three types of emergencies. Hekita hol national emergency on the ground of war or external aggression or armed rebellion under Article 352. Then state emergency or president's rule on the ground of failure of constitutional machinery in the states under Article 356 or failure to comply with the directions of the center under Article 365. Then we have financial emergency on the ground of threat to the financial stability or credit of India under Article 360. Emergency provisions or karone ami belegta chapter bhalke discuss korim, kintu etialoke amar 350 to state emergency dia hoise, kintu Article 360 er under financial emergency etialoke India declare hua nai. Next, three-tier government. The 73rd Amendment Act of 1992 gave constitutional recognition to the Panchayat or rural local governments. It added a new part 9 and the new Schedule 11 to the Constitution. Then the 74th Amendment Act of 1992 gave constitutional recognition to the municipalities or urban local governments. It added a new part to the Constitution, that is the Part 9A and the new Schedule 12. Then, Co-operative Societies. The 97th Constitutional Amendment Act of 2011 gave constitutional status and protection to cooperative societies. So it made the following three changes to the Constitution. It made the right to form cooperative societies a fundamental right under Article 19. Then it included a new DPSP on promotion of cooperative societies under Article 43B. Then it added a new part 9B in the Constitution, which is entitled as the cooperative societies. It includes Article 243ZH to 243ZT. Then at last we have criticism of the Constitution. So a borrowed Constitution. So kisamane koisil je the Constitution of India is a borrowed one. Why? We know that the Constitution makers have gone through the Constitution of almost 60 countries, and various provisions of the Constitution of India have been taken from different constitution. Hekarone koisil je the Constitution of India is a borrowed constitution. Then a carbon copy of the 1935 Act. We know that most of the provisions of the Constitution have been derived from the 1935 Act. So it is a carbon copy of the 1935 Act. Then un-Indian or anti-Indian. Why? Because it does not reflect the political traditions and the spirit of India. Kismane koisil je the foreign nature of Constitution makes it unsuitable to the Indian situation or unworkable in India. Then an un-Gandhian constitution. Why? Because it does not contain the philosophy and the ideals of Mahatma Gandhi. They said that the constitution should have been raised and built upon village panchayats and district panchayats. Then, elephantine size. We have already discussed that the constitution of India is the lengthiest written constitution in the world. আৰু ইয়াৰ ফেক্টৰ কেইটা আমি আগতে ডিসকাস কৰিছো. Then, paradise of the lawyers. কিছুমানে কৈছিল যে the constitution of India is too legalistic and very complicated. They opine that the legal language and phraseology adopted in the constitution makes it a difficult document. গতিকে প্যারাডাইজ অফ দি লয়ার্স কিয় হৈছিল? কাৰণ most of the members of the Constituent Assembly were from legal background. এইখিনি আমি আগতে ডিসকাস কৰিছিলো. So at this we come to the end of this video. Hope you like the video. If you like the video, please share it and subscribe to our channel to get more updates on this. Thank you.